you have done your law, your LLM, and now you are pursuing your doctorate, PhD in the subject you have told is capital punishment.
Yes, sir. Law of capital punishment, and particularly focusing on its constitutionality and the rare doctrines, sir.
Okay. So my question is that why you are interested in coming to judiciary? Yeah. Because you have done LLM, you are doing PhD, and so whether the academy won't suit you, or you are having any other plan for coming to judiciary?
Sir, my actual aim is to become a judicial officer, but due to some certain hurdles or obstacles, or basically I was trying for the judiciary from last 2 and 3 years, but I could not succeed. Therefore, I did not want to create a vacuum in my studies, and also I wanted to explore and expand my horizon in constitution and criminal law. Therefore, in my postgraduate as well, I took a specialization of constitution and criminal law, and currently also I am working on the constitution aspect only. So it is just for creating a wider knowledge base, sir.
So how you will be able to discharge your role as a judicial officer in handling the matters and reducing the number of cases?
I would basically follow the law laid down in the both the procedural code, be it code of civil procedure or be it the Bharati Nagrik Suraksha Sanhita. I would follow the timelines prescribed in both and try to basically not to deviate from that. So these are the things that following the same I can do it, sir.
What is the reason for surging of the pendency in India in the courts?
The primary reason that can be said is more and the increasing number of adjournments. It is one of the most issue, and also to some extent the strikes or basically non-cooperation from the lawyers, or there are certain instances where the non-availability of witnesses and the procedural delays in sending the summons and other processes of the court. These are the few areas that basically lead to the issue of delay.
What role technology can play in helping in this to reduce the pendency?
Technology can play a very important role. For example, many changes have also been incorporated in the Bharati Nagrik Suraksha Sanhita. That is introduction of audio-visual mode wherever possible. For example, examination of the witnesses, etc., and sending of summons and other processes through the electronic modes. These are the issue, along with these certain other, for example, making the courts accessible to the parties, which also increases the accountability of the lawyers. So these are the few issues that have been incorporated, and further making more accessible courts through the online mode of filing of cases and other issues can help reducing the pendency, sir.
What is the role of magistrate in a criminal proceedings?
Sir, please pardon, sir.
What is the role of magistrate in criminal proceedings?
Magistrate is basically responsible for the trial. It starts from the cognizance stage. If the magistrate takes the cognizance and then conducts the whole trial, and if needed in certain cases also monitors the investigation, and where the case is triable by court of session, it also does the work of committing the cases.
What is the difference between a constitution bench and a regular bench?
as per Article 145 of the Constitution, a constitution bench requires a minimum of 5 judges, whereas in a regular bench, for example, in the case of Supreme Court, there can be 2 or 3 judges. So this is the basic difference, sir.
Okay. What is the difference? Explain the doctrine of pith and substance in constitution law.
This doctrine is basically used whenever whenever there is an encroachment of subject matter. For example, if any matter is prescribed in the state list, and say the union or the central government has made any law, and it seems that the union government has transgressed its boundary and made any law in the state list, then this doctrine comes into use, which basically provides that we have to see the essence or the pith or the main substance of any law. So if the main substance or which is called known as pith is outside the domain of any competent legislature, then that law can be struck down.
Okay. What do you understand by the basic structure doctrine?
The basic structure doctrine was propounded in the famous case of Kesavan Bharti, the state of Kerala. So basically, this provides the essence or which can be also in common parlance said as the skeleton of our constitution, or the basic values, ideals, and aspirations which cannot be done away with in our constitution. So these constitute the basic structure. However, in the Kesavan Bharti case, the court did not lay down the exclusive categories has not enumerated what constitutes the basic structure, and it has left open to the courts to interpret it. And if any provision or any amendment is violative of the same, then such an amendment or law can be struck down.
Okay. You are doing your PhD in capital punishment and rare of
Yes.
So, what do you, in your opinion, whether the death penalty shall be done away?
We have to see this from many perspectives. For example, when we consider the global perspective, then around 140 countries are of the view that we should do away with. But on the other hand, the security of the state has also to be considered in view, because thus any law and order or what jurisprudence suits to any nation depends upon the various factors. For example, the literacy rate, socio-economic condition, and etc. So these are the scenario, and one jurisprudence or philosophy does not fit universally. So I am in the mid of my thesis. I have completed 4 chapters out of the 7 chapters, and I have for perusal all the global era. So, but I am now examining currently what is the implementation of these foreign jurist or philosophies in India. So now I have to evaluate the same in the future, sir.
Whether in your opinion, the future of Indian judiciary, why the cases, criminal cases are rising, despite we are having so many laws which are having a lot of teeth, but still the criminal cases are on increase?
So this primarily can be said because of the lack of political will or lack of procedural enforcement machinery. The work done by it is not at all satisfactory, and it needs a strict consideration, because it is not about the prescribing harshest punishment or making deterrent laws. It is the machinery that has to be at the proper place to curb down the crimes. For example, in a nation like Dubai, no one dares to commit these number of crimes, because they know that their police will catch them at any cost. But in India, the whole thing the lag is on the procedural part. For example, there is no proper collection of evidence, and for the same, forensic evidence has also been introduced in the Bharatiya Nagrik Sanhita. So these are the some issues. Further issues such as victim protection, witness protection scheme is also not properly in place, though there is a scheme provided in the 2018, but that also is not that efficient. So these all the factors lead to hollow prosecution, and which leads to low conviction rate, that is around 30% only in India, sir.
What is the difference between judicial activism and judicial overreach?
So so there are three terms. Firstly, judicial restraint, activism, and overreach. So when we consider judicial activism, then, for example, if there is any subject matter or aspect in which there is no law, as was in the case of Vishakha, there was no law as per se for the protection of women at workplace. So the Supreme Court use its power under Article 142 and basically provided a set of guidelines. So this can be said as judicial activism. But when the judiciary extends this role further and it starts making laws, then it can be said that it is kind of a judicial overreach, because as per the Montesquieu's separation of power doctrine, every organ has its duty to work in its own ambit. So when the judiciary steps over in any other branch, it can be said as judicial overreach, sir.
What do you understand by the independence of judiciary?
Independence of judiciary can be said that non-interference of any other organ, for example, be it legislature or executive, and for example, judicial of these aspects, and when the judges are free from any sort of external influence while in appointment, while in their service condition, while giving judgments, these can be said that independence of judiciary, and there are many provisions regarding the same. And for the same reason, the National Judicial Appointments Committee, which was introduced by the 99th Constitutional Amendment 2014, was also struck down.
Okay. Can you tell about my last question, jurisprudence on marital rape in India? Should it be criminalized?
When we consider marital rape, then the dialogue is worth noting from both the sides. From when we consider from the right to equality or constitutional perspective, then when we go to the doctrine of hail or coverture, it can be said that the wife is definitely not a servant of his husband. But so in this perspective, we can say it should be criminalized. But on the other hand, when we consider the public policy, then it is difficult to do the same, to criminalize marital rape, because these instances took place within four corners of a house, and there may be lack of evidence or abuse of these law by the women or female groups. So there has to be a balance struck between the two, sir.
Okay. Saket.
Hello, Alok.
Yes, sir.
Alok, your thesis is about rarest of rare doctrine.
Yes, sir.
Okay. So if I were to ask you in one line, what are your views about death penalty? Should it be kept or it should be abolished?
According to my current knowledge, in India, it should be kept for certain categories of offenses, but provided the safeguards that should be kept for retaining the death penalty or imposing the same needs strict evaluation and strict enforcement, because there have been cases where where capital punishment has been avoided in a wrong way.
But how are you going to, make sure that these are strictly followed, for the simple reason that it is eventually a judge, a human, who has to make a decision, right? So what is the present system? Aggravating versus mitigating.
Yes,
So you
sir.
have to weigh the scale. But it is ultimately the judge who, being a human, has to take a call.
Yes, sir.
So there can be a subjectivity, right?
Yes, sir.
And on his decision would depend the life of a person.
Yes, sir. So according to in this perspective, one aspect that came into my mind is the final confirmation should be done by at least 5 judges bench, because one judge, two judge, three judge can differ. But if we prescribe larger benches and we say that only where it is passed universally, means all the judges are in the favor of prescribing death penalty, then it can be said that up to some extent or up to significant extent this can be reduced. Yes, no doubt they all can.
Let's suppose if we were to implement your suggestion
Yes,
that
sir.
yours. So what is the present scenario? What are the minimum judges in the Supreme Court that need to confirm a death penalty?
Sir, with regard to High Court, I remember correctly, sir. It is confirmation has to be done by two judges, and in case there is a dichotomy of view, then a third judge.
That I'm asking about Supreme Court.
So sorry, sir, I can't remember right now.
Okay, all right. So presently, it's a death penalty matter needs to be heard by a 3-judge bench. So if we were to implement your suggestion that you are saying 5 judges should decide whether a death penalty should be given, and it should be a unanimous decision.
Yes, sir.
All 5 should be recommended. There should not be even one dissent.
Yes, sir.
How will we implement that? Under what power? What section? What direction?
Sorry, sir, I can't remember.
Okay, that's okay.
Sir, I know how it is enforced in the CRPC, sir, but BNSS, sir, but I don't remember.
That's okay. That's okay.
Yes, sir.
Can you tell me any legal concept that's difficult to understand? As per you, any legal concept that is very difficult to understand?
No, sir.
So for you, all concepts are easy.
Yes, sir. There were for certain aspects, but with hard work and resilience, I have basically accepted.
Okay, let's assume there is a one concept which might be easy for you. But otherwise it might be difficult for a layman. And if you were to explain the same to a layman in simple words, how will you do that? Any example?
I would take help of stories, etc. For example, if I have to for concept of I have to explain the concept of res geste. So I can. Shall I explain, sir?
That's okay. All right. My next question would be, your sir asked you a question about difference between a constitution bench and the other benches in the Supreme Court, right? Where you
Yes.
mentioned Article 145.
Yes, sir.
So are you saying only constitution bench can decide on any constitutional issue? A 2-judge or a 3-judge bench of the Supreme Court can decide a constitutional issue?
When there is a constitutional matter which involves a substantial question of law general then sorry, sir, I can't remember, sir.
That's okay. Let's suppose you're deciding a case, okay?
Yes, sir.
And a senior judge of your court tells you to decide the case in a particular way.
Yes, sir.
So what is the first thing that you're going to do?
I would decide the matter according to my knowledge and the evidences before me. But in case there is a strict pressure or direction, then I will recuse from the same, sir.
So even if you have heard the case for quite some time, each and everything, judgment is ready. So you'll recuse.
So in case if the direction or the pressure is so up to some such extent that I have to either bind by it or some consequences may follow, then I.
So my only concern in that case would be, let's suppose it's a repetitive thing.
Yes.
So now a senior judge gets to know that you'll easily recuse yourself and you are independent judge. They don't want a decision from you. So they'll simply say you and you'll recuse.
Sorry, sir.
Might be a
Yes,
possibility.
sir. Yes, sir.
That's okay. Let's suppose you're deciding a case and there is no legal precedent. Okay.
Yes.
On a particular issue that you're deciding. How will you approach your judgment?
Sir, if sir, provision regarding to same has been provided in the Code of Civil Procedure and Procedural Laws, and I will take assistance of power of reference, and I will refer the issue to the I will refer the matter to the High Court for their opinion, and whatever on the according to the order or decision of the same, whatever they decide, I will decide the matter, sir.
So reference has to be in some particular cases, right?
Yes, sir.
Can you have a reference in every case?
No. Where the matter is not decided by the High Court or the Supreme Court and on any point of law, which is necessary for the determination of the decision case before me. In these cases, reference can be done, sir.
All right. Do you think, in a way, judges are also responsible for low conviction rate in our country?
No, sir, I don't think that.
Absolutely no fault.
Up to some extent, it can be said. For example, there is provision that judgment more than two shall not be granted, and a day-to-day hearing will be conducted. But there are certain circumstances where advocates plead for the adjournment and they prescribe. So these are some issues, but these are not that bigger issues. They should strictly abide by the same. But yes, sir.
All right. My last question. What are your views about same-sex marriage? You agree with the Supreme Court judgment?
With regard to same-sex marriage, I would say that a stance of Supreme Court that is not legalizing the same in India is correct, keeping in view the present standard, because though Constitution is a living document and Supreme Court which abides by the same, but we have to also keep into view the moral fabric of the nation. And if there is anything that is propounded or made legalized way ahead of the moral or community values or standards, then it may lead to backlash. So India is not still ready for any concept such as same-sex marriage, and the Supreme Court has done extremely well in giving some relief to the same-sex couples, but same-sex marriage is not that suitable right now, sir. It may be a decade later, sir.
All right. Thank you.
Thank you, sir.
Alok, my last question is regarding the death penalty only, because you are specializing in your PhD on that matter. The Nirbhaya murder case and also this Kasab matter. Nirbhaya murder case was a so high-profile case, which took so many years. Even on the last day, when the accused were to be hanged, Supreme Court sat even at night till 2 o'clock, 3 o'clock. And even so was the case in Kasab case also. Kasab was on videos were there where he was involved. And so why this type of things are happening? Is it also happening in other countries, because this is your subject of PhD?
Yes, sir.
Or it is happening only in India?
Sir, please pardon, with respect, for example, why it is taking too much long time, or despite being clear evidence, such long time, sir?
Yes, and even in a high-profile case like Nirbhaya, where the president has also rejected, Supreme Court has confirmed death. Even then, on the day prior to morning to be hanged at 2 o'clock, 3 o'clock in the night, also court said.
Sir, it is just to give a reasonable opportunity of being heard and following the.
How many times reasonable opportunities to be given?
Yes, sir. Sir, the main reason
It
for
means earlier it was not reasonable.
Sir, it was, but the thing is, the Nirbhaya incident took place in 2012. It was finally executed in 2020. The basic issue that I find in this 8 years of span was there was no strict guidelines or strict follow-up of guideline. For example, in this RG Kar rape case, the judgment of the session court was pronounced in 57 days. And so timeline is one issue. For example, now in the Bharatiya Nagrik Suraksha Sanhita, 30 days period and 60 days period have been prescribed for mercy petitions for it to be filed. So if we have to basically address this issue, we have to first prescribe the timeline for everything. For example, prior to Pranab Mukherjee sir, Honorable President sir, there were many mercy petitions which were lingering without any action. So these are various issues. For example, prescribing a timeline. Second, following that timeline. So if all these things are done, then this issue can be solved. For example, if there are evidences easily in 2 to 3 years, the whole conviction and execution can be done. But the whole issue lies between the timeline and non-observance of the same, sir.
See, in Arjika case, only the court has not given the death sentence.
Yes, sir.
Death sentence is given, then it has to be confirmed by High Court.
Yes,
then it will be going for review. It will go to Supreme Court. It will go to President. So that procedures are there. That
Yes.
is what I am saying. And even after clearance of all those hurdles, even then the Supreme Court is sitting at 3 o'clock in the night. This was my question, whether it is justifiable.
Sir, it is justified up to some extent because it is not that justice should be done. It should also be that justice should be seen to be done. For example, in Yaqub Memon case, there was some sort of objection raised by the executant at the last moment. And in order to show that justice is seen to be done, the court sat in the night, sir. So I think this is justified, sir. Yes, but I would say that prescribing of a fixed timeline and observance of the same should be done so that these delays are not possible. Yes, sir.
Okay, thank you.